પણ હેલો એટલે કરું તમને મારી મેટર ફોલો કરું.
સર આમાં એક છે ને
Yes, Mr. Joshi.
Sir, I'm sorry, sir. Before Mr. Joshi begins, can I take one indulgence, sir?
Yes.
Yesterday, Lordship permitted me to put in affidavits, which we have done.
Yes.
What we realized was that one fact that 7 cooperative societies have the same bylaws, which would have election on the basis of constituency, was left out to be put in. So this morning we have put in an additional affidavit of 2 pages along with the bylaws of that society. Lordship, permit us to take it on record.
Very well.
Only
you
that
send a soft copy to Mr. Gadvi, the court master.
sir,
Ask your respective
physical
counsel.
copy has come to your lordships.
Acha, theek hai, very well. And you have served a copy on all the other councils?
Yes, sir.
Yes.
Well,
May your lordships have the sir rejoinder in our matter at 259.
પ્લસ મિસ્ટર જોશી ઇઝ રિફરિંગ ઇન સિરિયલ નંબર
I'm not-
449.
yes, 4449 we have. Yes.
And there now your lordships have 259.
259 is a sir rejoinder affidavit on behalf of the respondent state.
And therefore 261 is enclosed along with it. So your lordships have the entire record.
251, 61 is the affidavit.
Correct. Same thing. It is-
76.
So this
It
was only,
is as an affidavit in this matter only.
very well. No, so that we could trace out only last evening because it got lost in the mail. Mr. Desai didn't have it. We asked for a second copy from my friend, so it might take a little time more than what I had anticipated. Because this
No, you take
rejoinder
your
we
time.
had.
No hurry. You take your time.
Lordship. So Manoj, it has been extensively addressed before your lordship. Now there are 2 contentions raised in principle. One is that the act is discriminatory and that it suffers from manifest arbitrary.
Right.
Now both these are elements of Article 14.
Yes.
And Manoj, the Supreme Court has laid down various tests as to how it has to be applied in relation to an enactment which comes for challenge. So Manoj, I would first like to
Yes.
So Manoj, I would first like to emphasize the tests which have been laid down by the Supreme Court as to whether an enactment is discriminatory or suffers from manifest arbitrariness, and whether, as per the affidavit of the state, etc., this statute meets with those tests which have been laid down according to Manoj the state. So Manoj, first kindly have a look at the principles of law. There, Manoj, your lordships have kindly have both compilations. One which Mr. Thakur had given to your lordships on the
Yes.
earlier occasion, and one which Mr. Desai probably has handed over in the morning.
Yes.
So kindly have both, Manoj, because there is a huge overlap of case law.
Correct.
So first, Manoj, I am referring to the judgment. So first, Manoj, I am dealing with discriminatory, the act being discriminatory. And I want to emphasize what are the tests which the Supreme Court has laid down. So must please have 2015.
Mr. Joshi, just 1 minute.
Next week, you can you are not there.
Yes, Mr. Joshi.
Kindly have Manoj 2015.
Mr. Ukani, can you please increase the volume? Yes, you may continue, Mr. Joshi.
I am first elaborating the submission about discriminatory, the act being discriminatory. And please see the tests which are propounded by the Supreme Court to examine the statute. 2015, volume 10, Supreme Court cases 681. This is at page 105 of Mr. Thakur's compilation.
All right.
2015, 10 SCC
वो compilation कहाँ है रणवीर?
681.
अलग रखा है, प्लास्टिक को, ये वाला. Page 105 is Junior Vidya versus Anil Ratnam.
Yes, ma'am. I will go by the paragraph since now I don't have the running page number. It starts at 105. I am inviting your lordship's attention to paragraph 14 on internal page 695 of the judgment. 14.
चौथा नंबर 105.
It is at 105.
Yes, yes.
Then I am referring to paragraph 14, which is at the printed page 695.
One one nine of the compilation of Mr. Thakur.
Yes, yes, Mr. Desai, yes.
Sorry.
Paragraph 14.
Paragraph 14. Now, permit me to go a little slowly because each individual element is important. 14.
Correct.
What follows from the above is that in order to pass the test of permissible classification, two conditions must be fulfilled, namely, that the classification must be founded on an intelligible differential. But please see what it means. Intelligible differential which distinguishes persons or things that are grouped together from others left out in the group. This is the first element. And two, that the differential must have a rational relation to the object sought to be emphasized, to the object sought to be achieved by the statute in question. If the government fails to support its action of classification on the touchstone of the principle, whether the classification is reasonable, having an intelligible differentia, and a rational basis germane to the purpose, the classification has to be held to be arbitrary and discriminatory. So, Manoj, two elements in this judgment is that what do you mean by intelligible differential is something which objectively distinguishes persons and things grouped together or left out. But most importantly, Manoj, this classification must have a nexus to the object sought to be achieved. A rational relation to the object sought to be achieved. Then must, these are the two, then must please see 2016. This is further elaborated as what do you mean by rational relation, etc. Please see 2016 volume 10 SCC, page 165, which is at at serial number 2 of Mr. Desai's compilation, at page A of Mr. Desai's compilation. This elaborates of how do you apply those tests. Page 165.
Yes, we are just coming to page 165.
That is at page 8 of Mr. Desai's compilation, our compilation.
Which paragraph you are relying on?
Paragraph 13 on internal page 179. Printed page 179. Mr. Desai, SCC has been given, isn't it?
No, this is Mr.
Here.
You are referring to the compilation given by your
My compilation.
Today. It is given
My
today.
compilation today
yes, we got it.
at page number 8 of that compilation.
I'm sorry.
2016 10 SCC 165 at 179 printed page.
I'm
Yes.
sorry. Have you shared with us? I'm not very sure.
I'll share. I'll just share. I will just share. I forgot. I shared with Ms. the learned advocate general. I'll just share. Very sorry.
Thank you, sir.
Paragraph 13, dear lordships, have on 179.
Yes, yes.
In Shashikant Lakshman Kale, sorry, my lord the Chief Justice, my friend.
Yes, yes.
179 printed page.
Yes.
Paragraph 13.
Yes.
In Shashikant, etc., this court was faced with the constitutional validity of an exemption section contained in the IT Act after referring in detail to so and the propositions laid down therein on Article 14 generally and a few other judgments. This court held. Now kindly see the process to be adopted by the court. It is first necessary to discern the true purpose or the object of the impugned enactment. This has completely been missed by the state. They are busy trying to distinguish it. It is first necessary to discern the true purpose or object of the impugned enactment, because it is only with reference to the true object of the enactment that the existence of a rational nexus of the differentia on which the classification is based with the object sought to be achieved by the enactment can be examined to test the validity of the classification. In Francis Bennion, the distinction between legislative intention and the purpose and object of the legislation has been succinctly summarized in 237 as under. The distinction between purpose or object of an enactment and the legislative intention governing it is that the former relates to the mischief to which the enactment is directed, which is only expenditure in our case. Mischief to which the enactment is directed and its remedy, while the latter relates to the legal meaning of the enactment. There is thus a clear distinction between the two. While the purpose or object of the legislation is to provide a remedy for the malady, the legislative intention relates to the meaning or exposition of the remedy as enacted. While dealing with the validity of a classification, the rational nexus of the differentia on which the classification is based has to exist with the purpose or object of the legislation. Very important one. Has to exist with the purpose or object of the legislation. The question next is of the manner in which the purpose or object of the enactment has to be determined and the material which can be used for this exercise. Please see 70. For determining the purpose or object of the legislation, it is permissible to look into circumstances which prevailed at the time when the law was passed and which necessitated the passing of the law. For the limited purpose of appreciating the background and the antecedent factual matrix leading to the legislation, it is permissible to look at the statement of objects and reasons of the bill which actuated the step to provide a remedy for the existing malady. In Thangal, etc., the statement of objects, please mark this, was used for judging the reasonableness of a classification made in an enactment to see if it was infringed or was contrary to the constitution. Kindly mark the next line, which Mr. Trivedi has also stated. In that decision, for determining the question, even an affidavit on behalf of the state of the circumstances which prevailed at the time when the law thereunder consideration has been passed and which necessitated the passing of that law could be taken into account, was relied on. It was reiterated in Bengal, state of Bengal, that statement of objects and reasons accompanying a bill, when introduced in parliament, can be used for the limited purpose, etc. Then Manoj, next paragraph, similarly, next unnumbered paragraph. Similarly, in Pannalal, a challenge to the validity of the classification was repelled, placing reliance on the affidavit filed on behalf of the CBC, disclosing true object. Then was 14. Please see the principle again. In Harbans Bansal, the scope of 14 has been authoritatively laid down by this court in innumerable decisions. I will skip that. To be permissible under Article 14 of the Constitution, a classification must satisfy two conditions. Classification must be founded on an intelligible differentia, which distinguishes persons or things grouped together from others left out of the group. The differentia must have a rational relation to the object sought to be achieved by the statute. The classification may be founded on different bases. What is necessary is there must be a nexus between the basis of the classification and the object of the act under consideration. Then, Manoj, it is applied to the facts of that case. Then please have a look at paragraph 32, that your lordships will find at internal page, type page 192, printed page 192. Kindly have a look. 32 onwards is relevant, but must I will read paragraph 34 at page 193, just above placitum G.
Not 32?
32 onwards is relevant, Manoj, but for the present, Manoj, paragraph 34, just above placitum G. 32 again reiterates the same thing, Manoj, so I am skipping that to avoid duplication. At 34, just above placitum G, Menka Gandhi's case,
Yes.
and went on to hold that the burden to affirmatively satisfy the court that the twin test of intelligible differentia having a rational relation to the object sought to be achieved by the act would lie on the state once it has been established that a particular piece of legislation is on its face unequal. Then, was on the facts of the case, kindly turn over to paragraph 35. Again, Manoj extracted paragraph 42. Now this is Manoj very relevant. If it appears to be undisputable, as it does to us, that the pensioners for the purpose of the pension benefits form a class, would its upward revision permit a homogeneous class to be divided by arbitrarily fixing an eligibility criteria unrelated to the purpose of the revision? Now, Manoj, I emphasize this. And would such classification be founded on some rational principle? I highlight this. Rational principle. The classification has to be based, as is well settled, on some rational principle. And the rational principle must have a nexus to the object sought to be achieved. Then, Manoj, please see placitum F, 2 lines above placitum F. 2 lines, 2 words, the artificial division stares into face and is unrelated to any principle, and whatever principle, if there be any, has absolutely no nexus to the object sought to be achieved by liberalizing the pension scheme, then the court says it is counterproductive, etc. So these are the principles which the Supreme Court has said that classification based on intelligent differentia, rational relation, and a rational principle. Now, let's kindly break this up and apply this to our case now. So, first point is whether there is a rational principle of distinction between the group of societies which are left in and the cooperative sugar factories which are left out or excluded. So, rational principle, and whether there is a real and substantial difference between these classes. This is the test which I am summarizing, which needs to be applied. So, rational principle and real and substantial difference between the cooperative societies and the other class of society. So, must I start by saying that my effort is halved because they were admittedly forming one class, even according to the legislature. So, that is the first point which I am placing for your Lordship's consideration. That I need not show that they form one class. It is the legislature, when it introduced the 1981 Act for the purposes of Section 74C, which said that cooperative sugar factories are the same class as the other societies which are included in 74 capital C. Now please see, my lords, therefore, exclusion from that class will involve a supervening event, point one, and two, something which is not in consonance with the objective which was sought to be achieved by the 1981 amendment. So please see, my lords, the statement of objects and reasons of the 1981 amendment. Your Lordships will find that at page 293. When 74C was brought in, Mr. Jani has extensively taken your Lordships to 74 capital C. For the purposes for which I am emphasizing, it is free and fair election and proper representation. Just to summarize now. So first let me now read 293, since your Lordships are already on the paper book. Please see page 293 of my petition. This is the affidavit of the state where the objects are given.
You are referring to the affidavit of the state.
That's right, and two annexures which are at 293 and 294.
Diabetes, sir.
Lordships kindly have
Is
293.
the object of introducing 74C.
That's right. That's right. Because now I am sought to be excluded. So it is necessary to place in context why we were included.
Yes.
Because Manoj, my submission is the exclusion must have something to do with why we were included and now excluded.
They have to justify that. Why are they excluding it now?
So correct, exactly. So Manoj, for that background, please see why all of us were included. 293. Under the very relevant was every line. Under the existing provision of the Gujarat Cooperative Societies Act, a committee of a cooperative society is constituted in accordance with the bylaws of such society. With the result that the constitution of the committee of every society is different in each case. First element. In order to introduce a uniform system of elections for the members of a committee as well as its officers, insofar as certain categories of societies are concerned, it is considered necessary to amend the Act. It is also considered necessary to prohibit a person from holding more than 2 posts of officers in certain societies or from holding the post of officer in more than 6 years in such society, and also to provide for reservation of certain seats in the committee of such societies for scheduled castes and scheduled tribes, and also for marginal farmers and small farmers. So one is uniformity, and that the existing provisions as per elections as per bylaws is insufficient. Please see the next page, the 82 amendment statement. Why the Apex Society amendment came in. While administering the Gujarat, just the next page, 294. While administering the Gujarat Cooperative Societies Act 1961, it is found that existing provisions therein are not adequate to meet with certain aspects of the cooperative movement, such as existence of financially not viable societies in the same economic activity. Please mark this: emergence of vested interests of gaining control over cooperative societies, etc. It is therefore considered necessary to make adequate provisions in the Act for the purpose. Your Lordships will find at that stage it was thought fit to bring in uniformity and to actively prevent vested interests from gaining control of cooperative societies under the 1982 amendment. There is no reference to financial stake of the government. The government, Manoj, is trying to find out justification later. Only note at this stage that certain classes of societies, there was no question of financial stake of the government at the stage why 74C was brought in. Now, this was challenged by societies who did not want independent provisions of election to come in. Was only mark two things as far as I am concerned. 74C has two very vital elements, which Mr. Jani has elaborated. I am only narrating very briefly. One is, my lord, the constituency-wise representation. Two very important elements. Constituency-wise representation, which means that one person or one member in his taluka is entitled to vote for his representative alone, and it is the will of the majority in the constituency which will prevail. This is a very important distinction brought out by 74C, read with the rules, more particularly 3A, 3B and 4. I need to just point that out, Manoj, to elaborate it. The distinction is, Manoj, that if this constituency-wise election is not maintained, then, my lords, the larger constituency members, their views and votes will prevail, and there will not be a true representation, constituency-wise, by the members of that constituency. I hope I am clear, Manoj. Therefore, must please have a look at 74C for a minute. I'll just touch two or three issues. It has been extensively read. Please see the salutary provisions which are brought in. And I am only, as I said, emphasizing these two issues. 74C says, you lordships have 74 capital C.
Yes.
It says under subsection 1 that the following societies are considered as a separate class, and just the fourth line, shall be subject to the provisions of chapter 11A. Fourth line of subsection 1. The election of the members of the so-and-so shall be subject to the provisions of 11A. So, Manoj, this class of societies is considered worthy of provisions of free and fair elections under chapter 11A, which is 145 capital A, section 145 capital A. 145 capital A, your lordships will find. Apart from the other, Mr. Jani has extensively read disqualification, why it is necessary, etc. Please see two elements, 155U. 155U. He has emphasized this independent tribunal.
145 you said.
So 145, sorry, man. What did I say? 145U.
U as in umbrella.
Umbrella.
Disputes relating to elections to be submitted to the tribunal.
So, Manoj, there is an independent tribunal which Mr. Jani has highlighted. I'm focusing on that. And then, Manoj, kindly have why 145, why rules to be made.
Yes.
Now, Manoj, rules to be made are Gujarat specified cooperative societies election to committee rules.
That 1982 rules.
1982 rules. There your lordships may very quickly have 3 capital A.
And those rules are framed apart from other sections invoking section 145Y also.
It is, Manoj, under 145Y.
145G, 145U.
Yes, 168, 145G, U, Y. So why? Your lordships have been taken to 3 capital A. 3A, 1, 2, 3, etc. deals with constituency being, please see 1. In every society where there are more than one constituency, so and so, a provisional,
Yes.
a provisional list of constituencies has to be prepared under 1. Then must kindly skip 2, 3, 4. Kindly come to 9.
Just a minute, Mr. Joshi. Yes, Mr. Joshi.
Then Manoj, sub-rule 9 of 3A mandates that if it is notwithstanding anything contained in the rules or bylaws, if it is not done, the collector has the authority to divide it into constituencies. Please see 4 in the context of what the Honorable Court had inquired, that it has to be constituency wise. A provisional list of voters shall be prepared in Gujarati for every society, by every society in which the general election is due to be held. Persons who are members on the date of drawing up of accounts of the year in which the election is due shall be included in the provisional list. If different constituencies are provided in the bylaws, the names of the voters shall be arranged constituency wise as laid down in the bylaws. So two salutary features which I am emphasizing. One is constituency wise representation, and election tribunal being an independent body. These are elements of free and fair election and proper representation in a democratic setup, and are pillars of democratic governance. Mr. Soparkar just indicated at the outset that no, but societies also now have constituency wise. That is not irrelevant. It is left to the discretion of the society whether it has or not. I am on the government act, the legislature's action at the first stage. I will deal with the part later if some society voluntarily has constituency or not. This is a mandate that society, the majority has no discretion. This is a mandate of the legislature that you will have constituencies if your area of operations is more than one taluka. Election will be constituency wise, which is a pillar of proportionate and proper representation. Now must kindly come back to 74C, which gives an indicator of why such a class. 74C, it has nothing to do with financial input of the state. 74 capital C. Your lordships will find some indication in 74C itself.
Yes.
Your lordships may find the clause which permits the government to add to the schedule. 74C 1 Roman 7. Any other society or class of societies, lordships can you hear me?
Yes.
Which the state government by general or special order published in the official gazette from time to time specify in this behalf, regard being had to the financial position and share capital of such institution. Must two elements could be the financial position and the share capital of the institution. That means its members' contribution, etc., or the scale of operation. Some indication of what constitutes a parameter for the class which has been included in 74C. Before I go further, Manoj, please see, your lordships will find at page 27 the membership of the societies. At page 27 of my petition, membership and turnover, and please see the scale. Just kindly run down, my lords, column C and D of page 27. The first society has 7,500 members. Sorry, my lord the chief, page 27. I'm sorry.
All of you have given us so many papers to handle that.
Yes, sir.
Okay. Yes, page 27.
Page 27. Kindly run down, Manoj, columns C and D.
Yes.
The first society has more than 7,500 members and 116 crore turnover. Column C and D. The second society has 18,500 members. So elections, transparency, voting, etc. And 400 crores turnover. The third has 16,500 members. 351 crores. 24,500 members. Kindly see the districts also, Mano, in the first column. 3 districts, 8 talukas, 446 villages, 367, 185, 320 villages. Over the page, 153 villages, 5,500 members, 700 crores turnover. Item 5. Then 6, 210 villages, 15,500 members, 350 crores turnover. 5 talukas, 21,000 members, 66 crores. 600 villages, 23,000 members, 293 crores. Please see the scale of the society and the importance of the elections for such a huge number of members. So they were Manoj, that class, transparency in election, etc. The societies themselves or the persons in control have never been for this fair procedure under 74C. They challenged it at the first instance before this honorable court. And please see why it is upheld, which is also important because our exclusion must have some relation to why our court said that these provisions are necessary. Please, I am allowed page 1 of Mr. Thakur's compilation, 84-2 GLR 1244.
Yes.
Please see paragraph 60 on printed page 1302. I want to invite your lordship's attention to this because of affidavits being filed by the state that in fact it was only money being given by which this class was upheld. Please see paragraph 60 on page 1302. Please see what the court accepted. The state may have said anything. Please see what the court accepted. Para 60. Please see their case as recorded by the court. As regards, sorry, your lordship, para 60, 1302.
Page 60.
Paragraph 60, para 60, printed page 1302.
Right.
Mr. Desai can give the running page.
It is running page 46. Yes.
46. Para 60. As regards section 74 capital C, the case of the state government is that with a view to ensure impartial and independent machinery for conducting elections in cooperative society, that the same has been introduced as suggested in the conference of the representatives of cooperative societies in the state. Please mark this, Manoj, that it was brought in to ensure impartial and independent machinery. To digress for a minute, Manoj, the exclusion could have been justified on the ground that there is some statute in respect of cooperative societies, in respect of their elections, which ensures impartial and independent machinery in respect of their elections. So not necessary. There can't be an exclusion that it is too expensive. Your focus was ensure impartial and independent machinery for conducting elections in cooperative society. Please see how the court upholds it. Para 66.
Yes.
Para 66. Running, it's on 1306. Printed 1306. This takes us to the challenge to 74C, which provides for conduct of elections of certain specified societies in accordance with 11A. It should first be examined as to whether the impugned provision is violative of 19(1)(g), and if necessary, examine whether it offends 19(1)(c). At the outset, it must be emphasized that 11A, which contains detailed provisions as to how elections are to be conducted, is made applicable by these provisions contained in 74C only to apex societies as may be specified by the government by a general or special order in the official gazette, or district central banks, primary land development, taluka sales and purchase union, sugar factories and spinning mills. It cannot be gainsaid, please mark this, that the conduct of the elections to all these offices, which are almost in the nature of public offices, having regard to the important functions these societies discharge, nothing to do with 1 crore being given by the government or 20 lakhs being given by the government. That is too trivial a consideration. Having regard to the important function these societies discharge must be so conducted as to inspire confidence amongst members, in particular, members of the public at large, etc. It does not require much of an imagination to appreciate that many malpractices are being committed, etc., which my friend read. Then mark 67. As regards the challenge on the ground, we are of the opinion having regard to the class of society which have been specified in the 74C and the nature of functions which they discharge, the test to be applied for determining the value of the restriction from the angle of the doctrine of intended and real effect as laid down in Menka Gandhi's case. Please see the last line of paragraph 16, last 2 lines. The restrictive provision in election is valid, in the section is valid, since it is reasonable and in the public interest. So, my lord, 74C is brought in for the laudable object that looking to the society's important function and to ensure transparency and fairness of election, this is absolutely imperative. As I said, the exclusion must conform to these requirements, that it is equally being taken care of if we take you out, because there is some statute which obliges you to undertake similar obligations, which is absent in this case. So the reason for bringing us in was this. Then, Manoj, so this is the background. In this proportional representation, please see the importance of both. Please have a look at page 1 of our compilation. 1972 1 SCC 719. Page 1 of our compilation. Why it is so important?
Listen.
Paragraph 9 and 10 on pages 724 printed. 9, 10 and 11. The rival contention, sorry, page 724. The rival contentions which fall for determination are whether the right of vote for election of a member of the Committee of Management is confined to the delegates of the members of that particular constituency, or whether a delegate would have the right to vote for all constituencies constituting the Committee of Management. As the power of the registrar to interpret 409, it appears that the rule does not confer a power on the registrar to interpret or to express views to guide the rights of the members to vote at the AGM. On the contrary, this is not as far as the power of the registrar is concerned. About 8 lines or 10 lines into para 10, therefore under rule 409, therefore under 409, a corporate society can divide its membership into different groups or territories or any rational basis for the purpose of election of members. Rule also empowers the society to apportion the membership of the Committee of Management amongst different groups. The number of proportion of members of the Committee of Management will have to be apportioned in a manner that different areas or interests into which the membership of the society is divided may obtain suitable representation on the Committee of Management. The entire purpose of division of membership into different groups and specifying suitable representation of such group on the Committee of Management is to emphasize the right of the particular group to send its representative to the committee. To illustrate, if a society is divided into 14 separate groups on a territorial basis and one member of the committee of management is allotted to each group, and if delegates of one group have the right to cast 14 votes, two consequences will follow. First, the right of choosing the representative of the constituency will not be confined to that constituency, will be enlarged to outsiders in other constituencies. Secondly, a member of the committee from one constituency may be elected by a majority of votes from delegates of other constituencies.
Yeah.
So much it follows on the same line. So this is what they say is a very elementary pillar of proper representation. Now what has happened in the facts of the case is that if it is rule 3A8 says, if you have more than one talukas, you will need to have as many constituencies as there are talukas. And it is how it is interpreted by the state. The size of the taluka may be different, means the members in a taluka would be different in each case, but they are entitled to have their own representative on the board. What would happen if this is not there is that if one taluka has far larger number of members, if all votes are to be considered, if one member votes across talukas, there will not be proper representation of the members in respect of their own taluka. It will be colored by votes of persons residing outside the taluka. This is what the Honorable Supreme Court has said of proportional and proper representation. So this is salutary feature. Now this is upheld also by our full bench which has gone to the Supreme Court. Kindly see page 89 of Mr. Thakur's compilation. 2015-13 SCC 401. This is page 89 of Mr. Thakur's compilation. Here also, my lordships will note that the societies refuse to comply with the provisions of Rule 3A8 and hold elections as per the requirement of law, which is why the matter had gone to the High Court. At the instance of members who said that the law is not followed, the Supreme Court, Manoj, in paragraph 21 on printed page 411, has this to say about the constituency-wise representation. Page 411, para 21. Printed 411-21. It is obligatory on the part of any specified society to bring about amendment in its registered bylaws in conformity with the provisions of the rules and particularly 3A, 8 and 9. But if the societies have not amended their bylaws, the same has to be in conformity with the rules by getting it suitably amended. The effect of the rule would not stand nullified or inoperable. For this purpose, 9 gives a power to the collector to delimit the constituency. Thus, please mark this, once the area of operation of a society exceeds more than one village, which it does in all cooperative societies, exceeds more than one village as per sub-rule 8, the number of constituencies is required to be bifurcated by the collector in exercise of his power so as to make it equal to the total number of seats, to see that effective representation is given to the members of the society, for giving fair representation to its members, to elect their true representatives to participate in the affairs of the society as part of the managing committee members, as the society must be represented by elected representatives in a democratic process to effectively represent in the managing committee, which is an indispensable parameter for democratic institutions to achieve the laudable object of cooperative movement. Please see the focus on representation by the constituency of its members for its own representative being so important. Then must paragraph 23 relevant. Again, it is emphasized. Then, my lords, the other element of free and fair election being an election tribunal, your lordships will find it extracted at page 414 in Quixote Holohan's case, page 414. Just over para 25, extracted para 179.
In your compilation.
I am reading the same judgment, 2015-13. Your Lordships have 2015-13 SCC.
Oh, yes, of course.
I just read para 21
122.
there. Kindly go down to Manoj para 24, but at page 414.
Yes. Yes.
Where at extracted 343, there is yet another extract at 179 at 414.
Quixote Holohan.
Yes, please see, democracy is a part of the basic structure of our constitution, and rule of law, free and fair elections are basic features of democracy. One of the postulates of free and fair election is the provision for resolution of election disputes, as also adjudication of disputes relating to subsequent disqualification by an independent authority. So, Manoj, therefore, to summarize, 74C comes in free and fair elections, proper representation, independent authority, and constituency-wise representation. All salutary features of democracy and the electoral process. And this is upheld by our court. In this context, Manoj, if it was according to the legislature itself, the existing provisions of the bylaws were not adequate. Looking in some societies, looking to the nature of the functions performed, it was necessary to bring in 74C. What is the object of excluding us? This must be read in the context of what was the object of bringing us in and what purpose was achieved. So please see, my lords, the statement of objects as far as the present amendment is concerned. That your lordships will find. The English one, my friend may have to assist me, I have the Gujarati one. Mr. Desai can indicate where the English is in their affidavit, my lord. The statement, now I am coming to applying those tests which the Supreme Court had laid down. Your lordships must recollect, the Supreme Court said first find out the object which is sought to be achieved, so that the classification can be related to whether it subserves the object. So first test is find out the object. In that context, I had said that there is an umbilical cord between this and why we were brought in. So I read why we were brought in, what purpose it serves. Now please see the object presently, which is in page 86 in Gujarati in my petition, but in the Mr. Thakur's petition, it is in English, page 86.
In reply to Mr. Thakur's petition, it is English version is produced.
415.
Mr. Joshi, you may read it, but we have gone through that particular translation.
So right. So I am not reading it. So Manoj, two things they have said. The two reasons have nothing.
Two reasons: finance, that the expenditure incurred,
And the time of the
and
collector.
the time of the collector. You are emphasizing on this.
Right. Now Manoj, so as the Honorable Supreme Court said, what is the object of the legislation as discernible from the statement of objects and the affidavit? Please draw a distinction between their attempt to show why we are different. Please ignore it. It is irrelevant unless they show a nexus to the object. So what the Supreme Court said is first find out the object of the legislation as distinguished from what is the basis for classification. So if I focus on the object of the legislation, the statement of objects and reasons is undisputedly that you will save 8 lakhs. On the face of it, irrational, because the society still undertakes that expense. On the face of it, it is absurd. The expenditure element, which my Lord the Chief Justice also noted, one way or the other, you are bearing the expense. So therefore, Manoj, what is object of the legislation? Your Lordship, I dare say there is no object discernible. Your Lordship thrice asked the question. Why are you excluded? Mr. Trivedi rightly said, wait for my turn. But they have already filed affidavits. They have already come up with a statement of objects and reasons. There is absolutely no object discernible. The object is, sorry.
In addition to what has been stated in the object and reasons, have they come up with any other object and reasons in the affidavit?
Yes. I'll invite your Lordship's attention to both. So much. First is expense, and second is administrative exigency. Please balance this against why we were included. Looking to the status, position, nature of functions, need for transparency, fairness in election, thousands and thousands of members being involved in the process. We were brought in 74C. Now, what is sought to be counterbalanced is, sorry, but maybe expense is high and the collector has no time. These are, my lord, this is not the, what is the public interest and objective of a legislation must be in the public interest. Every law must subserve a public purpose. Their law says the object is to save 8 lakhs and prevent the poor collector from running here and there. This is not the object of, so statement of objects and reasons are completely silent on what is a substantial or a rational ground. Kindly come to their affidavit.
Therefore, I was asking what have they said in the affidavit?
I have got it now. Kindly come to their affidavit. Kindly come to page 87 in my copy. As I emphasized, Manoj, for the time being, please keep the distinction aside that you are federal and you are primary and they are federal and you are. They could as well have said you are manufacturing sugar and the others are not. Therefore, there is a classification. It is irrelevant unless you know what is the object. So please see 87.
87 of
my petition, which is their reply.
Oh. ये निकाल दी petition अलग कर दीजिए बाकी application सब मिस्टेक्स काट दीजिए comfortable for us application निकलवा दीजिए अगर सब साफ हो गई
Their detailed, their affidavit starts at page 87.
Just 1 minute, Mr. Joshi.
Of my, yes, my petition. 4449.
Yes. Yes, Mr. Joshi.
Yes, 87, dear Lordships, kindly find that.
Yeah, we have it.
The first
Identified
applicable
Mr. Patel.
Yes, kindly have a look at after the initial Manoj paragraph. The rationale starts from paragraph 97, paragraph 9 on page 97. Sorry, Manoj, page 97, paragraph 9. 9.1. On account, my lords, can you find that?
Yes.
On account of various proposals made from time to time by various sugar cooperative societies and the Federation, as well as the grievance voiced by the Federation regarding the additional expense towards use of government machinery borne by the societies and ultimately by the members, so it is not exchequer, were looked into by the state government on account of the details regarding expenses and use of government machinery in the electoral process provided by the director of sugar. Deliberations took place and accordingly it was decided to delete the sugar cooperative societies from the list of specified societies. In view of the above, contention of the petitioners that the amendment is carried out without rationale is meaningless. They re-emphasize that cost being incurred by the society is sufficient to take them out of 74. That is the object of the legislation. Then, Manoj, please see some page 98.
No, read para 9.2 also.
When section 74A, B, C were inserted in the Principal Act for the first time in the statute book in 81, the state government, in order to promote growth of sugar industries as part of the agrarian reform, had substantially contributed to the share capital as well as extended loans or subsidies under the scheme. It is for these reasons an element of public interest was involved at the relevant stage. 81 of the Principal Act authorizes state government to nominate its representative on the board of the society. Thus, in the year 81, there were cogent reasons prevailing to include sugar factories under the list of specified societies under 74C of the Act. Kindly pause here for a minute.
So what change has come now?
Kindly, but pause here for a minute. First, it has nothing to do with object. First, now this obfuscation, please see through. This is classification. They are saying that today you don't have investment by state, which distinguishes you from the others.
Where was that the object in 1981?
It never was. So
How is that relevant?
I'm obliged now, that is exactly what I'm coming to. But Manoj, for the purpose of understanding the state's contention, so first thing, as your lordship said, it was never why you brought in 74C that state money can be protected. It was never a rationale why our court accepted it. They said looking to the nature of the functions, vast number of members. And when I'll show the...
You do one thing, Mr. Joshi. Read 9.3, 9.4.
I propose to read that. Kindly, Manoj, I am only emphasizing. Please, Manoj, while reading, have this distinction in mind as to their attempt to conflate two issues. First, determine the object so that the classification can be related. Their object is to save money. Then they are saying for that we have two classes and how you are different, which is irrelevant. As I said,
They are saving money of the society or the government?
no, none. They are saving money, Manoj, of neither. So, Manoj, the society continues to spend. An administrative exigency to avoid free elections. It's unthinkable. Unthinkable that the collector finds it difficult to ensure free and fair elections. That's unthinkable as a ground, as to counterweigh public interest. But please see 9.3. When the proposal suggesting amendment of 74C of the Principal Act was submitted by the Director of Sugar, overall assessment of the details suggested that gradually the contribution of the state government towards share capital in the case of sugar factories is substantially reduced. Annexed here with an marked annexure R7 is the copy of the statement showing details of the share capital contribution of the state government towards 13 working cooperative societies being recovered and repaid completely. Thus, the factor of public interest attached to the cooperative societies at the material time came to be substantially watered down as compared to the position prevalent when the amendment was introduced way back in 1982. Must please pause here for a minute. Public interest is only safeguarding money? Assuming this is correct, what about free and fair and transparent elections, warranted looking to the nature of the functions and the number of members? You want for 1 rupee, 1 crore 60 lakhs is the only public interest? Thousands and thousands of members who are dependent on democratically elected governance of their society is not something in the public interest? Please see annexure R7, their statement. That Manoj, your lordships will find. Mr. The paging has gone. Mr. Desai can please. R7.
R7 is a part of the counter affidavit?
Yes, yes, Manoj, but the paging in my copy has
125.
125, your lordships may see.
R7, yes.
Please see, Manoj, what, assuming their case, just examine it in perspective. Please see the huge public interest because of the investment. What is the investment? 1 crore 60 lakhs in the first, 1 crore 60 in the second, 2 crore 75 lakhs in the third, 20 lakhs in the fifth, 39 lakhs, 27 lakhs, 35 lakhs, 20 lakhs, 7.5 crores, 1.6, 9 crores, 2.77 crores. This, according to them, this 20, 30 lakhs or 2 crores, 3 crores, is the huge public interest which is no longer there. Because quite conveniently, these amounts are repaid by the persons in management.
So
The
that
whole
has been efficiently managed.
I am startled at the concept of the state to say that our investment of 1 crore was the only serious reason why we wanted transparent and fair elections. Startled, my lord. There is an element of irrationality to it. 18,000 members whose livelihood depends on the running of the cooperative society, free and fair elections to ensure that somebody doesn't capture power and stick on to it like a fiefdom, that the state doesn't say it is public interest. Then must please see 9.4 ahead. Another facile self-serving affidavit observation. Paragraph 9.4. At page 98.
Okay, sir.
At page 98, 9.4. I
Yes.
further say and submit that once the state government is a subscriber to the share capital, considering 81 of the Act of 61, normally such societies to be governed only by bodies elected, and in that view it should be autonomous. Thus, any interference by the state by nominating representatives, how is it relevant? What is the relevance? An election by the independent body before an independent tribunal, disputes are adjudicated, is certainly not interference if that is what they are hinting at. Because our court has upheld 74C and chapter 11 that it is transparent and fair elections. So this indirect hinting that, oh, it might amount to interference is being a little too cautious and quite irrelevant. So only two reasons in this. Now they filed that subsequent affidavit. Please see the object. Again, now please draw distinction between difference. Please see at page 269. They have filed a 259. They have filed a sur rejoinder.
Yes.
Again, Manoj, kindly have. They have annexed the affidavit which they had put in the other matter. And they have added two elements. Please see 269 where they have extracted what I just read. 269.
Yes.
That table. That public interest was only because of the 27 lakhs and 39 lakhs which we deposited. If I take the general case or 2 crores. So this is what they say. Then must please have 273 onward. 273. They are justifying that it is too expensive for you, for the society itself. 273. The table,
Yes.
paragraph 3.70, where their case is para 273.
82.
Sorry.
Yes.
So Manoj, 273, they are still on the object of saving money, which I have already said is irrational. But even there, your lordships may see a basic flaw. 273, they are saying that you had a profit of 1 lakh and your expense would be 8 lakhs, etc.
Yes.
First point is, Manoj, that the state is quite well aware that this is a cooperative society where the members are the producers.
वलसाड की सोसाइटी में इतना लॉस कैसे 22 करोड़ का हो गया?
Corruption is so wicked.
नहीं, बाकी सब पॉजिटिव चल रही है except for this.
Yes. और ये बैंक का ये मंडली का तो लिटिगेशन भी इतना होगा हमारे कोर्ट में. All politics.
Please see, Manoj, a fundamental flaw in this reasoning, which your lordships only find in the last affidavit. There, they are saying that you do not make enough profit. Now, Manoj, this is not a commercial venture. This is a cooperative society. Its members are producers. The profit is as dividend to the members. Sugar cane which is procured, there is a purchase price given to the members. Therefore, the element of profit is irrelevant. For example, societies have given 350 crores as procurement price to its members. This is not a case where profit has to be generated for the purpose of share market prices. This is a cooperative society. Both cases, even if there was profit or I pay higher procurement price, the money goes to the members. So let me give your lordships an example. If I am able to sell the produce at say 120 crores, it matters little if my procurement price is 118 crores and therefore profit is 2 crores, or my procurement price is 50 crores and my profit is 70 crores, for the reason that both monies go to members. Please see section 61 of the Cooperative Societies, 66 of the Cooperative Societies Act. So that this distinction, Manoj, I will just elaborate again, that this is again somebody's thought at the stage of Sir rejoinder. Mr. Desai, ABCD is with the court.
Yes.
Yes, please see 66.
Section
66, 66.
appropriation by profits.
That's right. So I will skip Manoj's 1, which is what is to be computed, etc. Please see 2. 66, subsection 2.
Right.
A society may appropriate its profits to its reserve fund or any other fund created by it to the payment of dividends to members on their share, etc. So the concept of less or more profit is irrelevant in a cooperative society. It is just surplus which can be divided amongst its members. Point one. Point two, in the arguments of Mr. Thakur, the learned Advocate General did say that what do you do with these hundreds of crores of turnovers? Most of you are running into loss, etc.
Yes, since yesterday the matter is going
In
on
that
before the
context,
beginning.
Manoj, if your lordships just have that ABCD compilation which Mr.
Started.
Desai has given
It
today.
is likely to
Stop.
change entirely
Mr. Prajapati,
what the expectation is, because I am also there and I have division bench, chief court.
Vote number 1, my lord. I
Vote
need
number.
You can phone
available
in.
only in the first half, however. In the second half, the honorable court is not available.
Depend by phone करना है.
Mr.
On this side or that side?
This side tomorrow or day after tomorrow. Tomorrow if it can be, or it can be time being kept at what? May I request for 2:30 in
Mr. Prajapati,
a minute, man. Hello.
Mr. Prajapati.
Inform.
But a glimpse of Justice Shastri's court.
So, my lords, can I continue?
Mr. Joshi.
See, this is disturbing. Please don't do this. The link gets snapped. We were on a particular issue. Let's concentrate on it.
Yes, Mr. Joshi.
Yes, not so. This profit part, I just want to indicate that apart from the fact that it is thoroughly extraneous, even this reasoning is flawed because profits have nothing to do with the importance of the functions carried on by the society. The fact whether it makes 1 rupee profit or 200 crore profit or whatever it is, it has no implication on the nature of the functions of such societies, the role it performs, by which the classification was upheld by our division bench earlier. In that context, I just wanted to point out that if your lordships have that ABCD compilation which my friend has given for your lordship, it's a printed balance sheet. So there should be no objection to that, my lord.
What is this ABCD?
I'm also sending to the learned advocate general. It is a 5-page, only 5-page a balance sheet, relevant extract of a balance sheet of sugar factories, along with today's compilation.
Where do I get Mr. Desai?
Half a minute.
No, where will I get? On email or on WhatsApp?
WhatsApp. Half a minute.
You would have sent me earlier in the morning.
Difficulty, it is not going in email. It is still in my sent box in my email. That compilation. I don't know why it is still in my sent compilation. I did send it to you.
I just want to show one entry. Mr. Trivedi will not find it difficult to just note it. Now, there's nothing elaborate I'm arguing on this. 273, if your lordships have in hand, kindly see item 9 there. Item 9 there on 273.
Yes.
Their case is that you are expending 28 lakhs while your profit is 48,000. Lordships have it?
Yes.
Now, just that's it. Now, let's kindly turn to page A. This is the same society.
Yes.
Along with today's judgment compilation, 5-6 pages of Gujarati, I have made ABCD paging. Along with today's judgment compilation in the pad, I have sent relevant extracts of a balance sheet. Yes, my lord.
Yes, बताइए.
Yes, please see, Manoj, the first line on the left-hand column, amount paid towards procurement of sugarcane, 579 crores, 52 lakhs, etc.
Yes. This is the figure.
In 1819, 579 crores has been paid to the members for procurement of sugarcane, and the produce was sold at 613 crores. So which is why I say this profit element is thoroughly irrelevant. Either way, the profit would have gone to the members. But the procurement by which the farmers have benefited.
Bardoli district. Bardoli is a district by Surat. Or it could be Tapi or Narmada.
Bardoli district कहाँ पर? Bardoli कहाँ पर?
सूरत में आएगा?
Down. Surat
It
district.
is in Surat.
I think
Well,
Bardoli is the biggest in the state, right? Bardoli.
Mr. Jani or Mr. Trivedi are the best Manoj to.
Yes,
Any-
Lord, it's big.
So Manoj, your lordships may see the next page also. ₹60 crores, 344 crores. So Manoj, I'm only pointing out.
For what purpose?
Their logic is that your profits are too low, so we are taking care of you. At page 273, they are justifying the objective that we are saving money. At page 273, by trying to tell your lordships that look, their profits are not enough. Their profits, poor societies, their profits are not enough. We are saving money. This is the object of the act, which is absurd. Because the turnover and the procurement price which we pay to our members is 300 and odd crores, 500 and odd crores. This pittance of 12 lakhs and 20 lakhs to ensure fair elections, no member will object. Apart from the fact that it can't be an object to save money for the society, for any law. I am saying that this comparison to profits is wholly colorable, it's misleading. It is as if to indicate that you are doing nothing else, earning hardly 8-10 lakhs or running into loss.
So according to you, one, if you had not returned the government's money before 31st March 2019, you would have continued as a specified society.
No, they would have found some other reason.
That's the reason which is given. So today, if you again take loan from the government, again you can't fall into that category. No.
No, not necessary. No, they have. That is not the reason for including. That is not. They are saying that public interest is not subserved.
Can I just say 1 minute? Even today, these societies have loans and financial assistance of the government. Even today, share capital. They are saying share capital.
Share capital has gone. Okay, I didn't.
Financial assistance still continues. Various sugar societies, financial assistance still continues.
Yeah, section 80 is necessary to be.
For share capital, section 80.
Say.
Yes.
Now, Manoj, they have summarized at page 275. So, statement of objects your lordships have seen. Affidavit essentially reiterates that at 275 now.
Paragraph 4.
Paragraph 4. The sum and substance of the aforesaid discussion clearly suggests that mainly the following 4 reasons have weighed with the government for excluding sugar cooperative societies from the list of specified societies. 1. They are not federal societies. Again, Manoj, it's an issue of classification. Kindly ignore it for the time being. That the others are federal and you are not. Has nothing to do with objective. I will deal with it when I deal with classification. 1. 2. Expenditure being incurred in conducting the election is on the higher side. So this is the object of saving money. This is not classification. Otherwise, Manoj, if it is classification, it would be for everybody. Save money for everybody. So object 2. 3. Collector who were responsible are overloaded. This can't be classification. It must apply to all. So it is an object. So object of the legislation is save money, save the collectors from working too hard. 4. Pertinently, in 81, when cooperative sugars were included within the list, the element of public interest was in the forefront. Before the state government enacted majority in existence, they had subscribed to the share capital. Again, now facile. This is not recorded by the court. This is not the justification for upholding 74C.
Therefore, from that point of view, element of public interest is now no longer present.
Yeah, this is in direct conflict with 1984.
Get me? Yes.
Amreli district, which is affirmed. Sorry, full Amreli district was followed by full bench.
Full bench.
And full bench is affirmed by the Supreme Justice Gupta with Justice Gupta.
That was good.
This again is an element of classification. So on the first test which the Supreme Court said, find out the object of the legislation. Then go to class. On the object of the legislation, there is nothing in the statement of objects or the affidavit except expense and administrative difficulty. Those in my respectful submission is no object at all. The object has to be rational, in the public interest, subserving a constitutional goal, or must be in the public interest, etc. So therefore, there is no object which is discernible at all. In that context, Manoj, your lordships have already noticed, on the other hand, that for the inclusion, what was the important nature of functions, number of members, turnover of the society, etc. your lordships have noticed. So Manoj, I am respectfully urging that as far as object is concerned, there is none. Now, even on classification, their attempt, and now you already read it, so I'll just summarize. They are seeking to distinguish the societies from the others by saying that you form a different class. One is, as stated in page 275, you are not a federal society. And 2 is that amounts are returned, so there is no element of public interest as far as you are concerned. Your lordships have noticed at page 275. Kindly keep that in hand, Manoj, 275. The classification point 1.
We have noted, Mr. Joshi. We have noted.
So first is that you are not a federal society. This does not help them for 2 reasons. At the stage I was included, my character was the same.
It has not changed since then.
Therefore, federal, primary, etc. is of no consequence at all. This entire argument is facetious. I was clubbed as one class despite my character being the same. Today they say you are not federal, etc. There is no change. It doesn't distinguish me. Once you have considered me as of one class, this parameter was irrelevant. You considered nature of functions, importance of the society. The office being an element of almost public office. Therefore, you can't bring in a distinction which was not relevant for treating me as one class at the threshold stage itself. Point 1. Point 2, being a federal society or not, assuming my friend is right, it must have a nexus with the object. If the object is saving money, how does a federal society or non-federal society have any bearing? You save money for all. If you have administrative difficulty, does it become less or more? So the classification has no nexus apart from the fact that their classification is not a principle at all. Where is any principle laid down in the entire matter? It is not a principle that it is a federal society or not a federal society. The issue is of free and fair election. Why do you want to exclude me from provisions which our court said are imperative for free and fair elections, whether I'm federal, non-federal, etc.? There is no nexus with why I was brought in the first place. So that is 2. Then the last they have said in this is item 4, the public interest element. That, as I said, Manoj, is really again irrelevant. This is to answer the argument that what has changed, they have brought this in. Again, my lords, 1.60 crores or 2.60 crores is not public interest so as to ensure free and fair elections. It is the number of members and the nature of work. So therefore, even if there was shareholding or no shareholding, there is no distinction in the nature of the functions I carried on in 81 and today. Therefore, this has absolutely no bearing. So therefore, on both counts, absence of any legal principle, least of all a rational principle, neither an objective is disclosed, nor a objective criteria for classification is disclosed. As I said, Manoj, the state would have been better off saying you manufacture sugar since you are out. Therefore, going into discussions on difference is not consequential unless you link it to objectives sought to be achieved, which is not there. That is how I conclude the first point. Second is manifest arbitrariness. So it must fails on Article 14, discrimination on both object and intelligible differentia. Then was manifest arbitrariness, Mr. Thakur and Mr. Jani have argued. Again, must please see the principle. When the court has to apply the test of manifest arbitrariness, what does the court look at? Please see now the book which has been given by Mr. Thakur, 2017, volume 9 SCC, page 1. That's a separate book which my friend had requested your lordships to have.
Yes.
Please have a look straight to para 95 as to how to apply this principle of manifest arbitrariness.
This is Shara Banu.
That's right, Manoj.
Paragraph 95.
95, it is on page 95, para 95. I propose to read 2 paragraphs, 95 and 101. And please demarcate, Manoj, those words which the Supreme Court has used to apply it to our case. On a reading of this judgment, my lord the Chief Justice, page 95.
Yes, yeah.
On a reading of this judgment, in so and so, it is clear that McDowell was not read as an authority for the proposition that legislation can never be struck down as arbitrary. Indeed, the court, referring to earlier judgments and Ajay Hasya in particular, stated that legislation can be struck down on the ground that is arbitrary, went on to conclude that arbitrariness, when applied to legislation, cannot be used. Now, Manoj, kindly see. Instead, it broad-based the test, stating that if a constitutional infirmity is found, 14 will interdict such infirmity. And a constitutional infirmity is found in Article 14 itself whenever the legislation is manifestly arbitrary. Now, please see how it is defined. That is, when it is not fair, not reasonable, discriminatory, non-transparent, capricious, biased, with favoritism, nepotism, and not in pursuit of promotion of healthy competition and equitable treatment. First element, please see the positive element. Positively speaking, it should conform to norms which are rational, informed with reason, and guided by public interest. So please, sorry.
When it is not fair, not reasonable, discriminating, not transparent, capricious, biased, with favoritism or nepotism, and not in pursuit of promotion of healthy competition and
Politically speaking, it should conform to norms which are rational, informed, with reason, and guided by
Correct.
public interest.
Yes.
So, Manoj, kindly recollect your lordship's query to all of us that why have they brought in this law? So, I have read the statement and the affidavit, completely opaque. The reason is obviously not the reason. Completely opaque unless my friend conjures up something from thin air. The documents don't disclose, the affidavit or the statement don't disclose. So much it is completely non-transparent, discriminatory, etc. So this is, then please see 101.
105.
101 at page 99.
Yes. That also was read yesterday.
Yes, but please see placetum C, just 2 lines. Manifest arbitrariness, therefore, just below placetum C.
Yes, yes.
Must be done by the legislature capriciously, irrationally, this, or without adequate determining principle. This principle is absent. They are going on facts. Principle. So this is manifest arbitrariness. In that context, Manoj, I have already, Manoj, indicated that it suffers from the vice of everything which the Honorable Supreme Court has stated constitutes an element of manifest arbitrariness, particularly when 74C ensures proper democratic elections and fair adjudication. To exclude me in the public interest will require something more than expense and administrative exigency. Your lordships have seen in our bylaws we have said that hundreds of villages are covered, thousands of members are also covered, and therefore this is therefore manifestly arbitrary. There is one last element on the aspect which touches manifest arbitrariness also, in the context of is it slanted towards some purpose, which the court has said favoritism, etc., but slanted towards some purpose, and what are the attendant circumstances? So, as your lordships will find that 3A8 or 3A, when it came in 1982, all these societies consistently continued to hold elections as per their own bylaws, because there would be lopsided voting pattern. The larger talukas or the larger chunks would overwhelm representation by the persons in their own constituency, to the extent that the government, fed up with this, had to bring out a circular saying that time is enough, please amend your bylaws. This your lordships will find at page 242. I want to show a consistent, obstinate stand of the societies that the management in power, they are there since decades, don't want to let go of the control of holding elections and also disputes, etc., through favoritism. Please see 242, paragraph 14.
242.
Yes, that is part of my reply. So part of my rejoinder.
Your rejoinder.
Yes, right.
नहीं नहीं इसमें आएगा सर है पीछे
ये
पैरा 14
अच्छा, all right. Internal page 8.
Internal page 8. Paragraph 14. It is submitted that till 2011-12, the sugar factories were sugar factories were holding elections in violation of 3, 8, and 9 of the so-and-so rules. Therefore, the registrar so-and-so, with a circular of 6/7/11, directed that all the specified societies shall hold elections in consonance with the so-and-so rules. Accordingly, District Registrar Surat, by way of communication of 12, informed all sugar societies to hold elections as per the so-and-so rules and bring their bylaws in conformity with the rules. Copies of the circulars are annexed. 15. I say and submit that in spite of the aforesaid, the elections of the sugar factories were conducted contrary to the Gujarat specified cooperative societies election rules, and therefore the matter came to the full bench. Just kindly, that is sufficient for this. Please see the full bench judgment in the same petition. Sorry, my friend Mr. Desai has something to say.
Only last two lines that the full bench declared this elections to be.
I know. I am taking my lords to the full bench decision. Kindly see the full bench decision, page 63 of the same petition, paper book, page 63.
Yes.
There again, one of the same thing happened. 3A8 was followed in the breach. Therefore, members approached page 70, after recording this, page 75, paragraph 30, so that your lordships see that the sugar societies also were quite obstinate in ignoring chapter 11A, para 30 on page 75.
Yes.
SCA so and so. This petition is preferred by 3 members and shareholders of Narmada Khan. So our group, our class. The prayers are made in the petition for seeking appropriate writ to quash and set aside the notification published for election of society question. One of the principal bases of the petition is that the area of operation of the society is more than one village, and therefore bylaws for election of the members of the managing committee has to be in conformity with the provisions of 3A. In spite of that, election is held as per bylaw number 21AB. Bylaw 21A would stand in conformity with Rub Rule A. Constituencies were required to be delimited, etc. Then the rest is not immediately relevant. Only that the societies were interested in not following chapter 11. Please see paragraph 31. Bylaw number 2 provides for election of 15 representatives, minimum so and so.
No, you skip that part. You start reading from Placitum 45 in para 30.
Exactly, I'm obliged. I just wanted most to invite your lordship's attention to Placitum 20, just the line below that. Area of operations is 40 kilometers, hundreds of villages. I just want to show that. Then, yeah, absolutely, page 45, I'm deeply obliged. In our view, should I start from there?
By implementation of the bylaws.
By implementation of the bylaws which are dehort the statute rule.
No, wait, 2 lines on the top of it. Had
the constituencies been delimited?
Yes.
Had the constituencies delimited as per statutory rule 3AA, the position would have been different, inasmuch as the voters of the said constituency would only be in a position to cast their vote and not of any other constituency. By implementation of the bylaws which are dehors 3AA, the consequence has arisen that the voters of other constituencies residing in the separate villages have cast their vote in favor of candidates which would otherwise not be permissible as per the scheme of 3A. In our view, once it is found that voters of one constituency, not otherwise provided in sub-rule 8 of 3A, have cast their vote for the representatives of another or a separate constituency, such would materially affect the result of the election, inasmuch as, example, Division 1 of Vaudi comprises of 50 villages, Rajpipla consists of 13. Under these circumstances, it appears to us that there is no proportionate representation of the voters for electing the representatives of their area. Hence, it can be said that the result of the election is materially affected. The aforesaid is an additional aspect to the aspect that the bylaws on the basis of which elections are held are not in conformity with the provisions of so and so. Then must finally the court sets aside those elections.
1 minute.
Last line. Yes, sorry. Sorry, sir.
Yes, Mr. Joshi.
That mute, unmute.
Sorry, kindly see the last 3 lines on the same page 76. Last 6 lines. Under these, the last 2 words of the sentence are, under these circumstances, we
Yes.
find that the election is vitiated, result materially affected, etc. Considering the facts of the present case taken on the legal issues, we have the considered opinion that the country will respond to. Now, kindly see that the contention of the respondents, which means the societies, to allow the elected representatives to continue to hold their office on a mere ground that the election of this type were held earlier does not deserve to be accepted. In the result, the elections held of the members of the managing committee of the respond number 4 society deserve to be quashed and set aside. Further directed that as the elections as per the scheme of Rule 8 shall be held at the stage delimitation will be made, etc. Until the election is directed, they will only manage as caretaker. So now this is 30 and 31 are in relation to cooperative sugar societies. Paragraph 30 and 31 are cooperative sugar societies which said we will not abide, we will go by our bylaws, have a composite election, went ahead, challenged, court said nothing doing. This is salutary. Please do it as per 3.8, election set aside. Please see what follows. 104. Please see the date of this judgment. This judgment
4th July.
is 4th of July 2013,
Page 63.
page 63.
Yes, yes.
So now, apart from other issues, etc., this triggers at 104, your lordships find an internal letter from the director sugar to the government, page 104.
Yes.
Please see the, I'll just read, Manoj, from the first line. Regarding the above subject, the state of Gujarat in its so-and-so department by 7/3 by its memorandum dated 7/3/14.
Pardon, sir. This letter was read out yesterday. This was not read out.
It is the same letter. The director writing to the secretary.
ये 2014 का
दो लिखा था ना, एक 14 का लिखा था, एक 19 का लिखा है।
इसका which is top secret.
हाँ, बहुत बदल
हाँ।
कल दोनों ही पढ़ा।
Yes.
Please see the fourth line, third line. પ્રમુખ માન્ય મંત્રી કૃષિ ગુજરાતના રાજ્ય અને સચિવ સહકાર વિભાગને તેમના 17/7/13 પત્ર વ્યક્તિ સભાથી હોવાથી 74C માંથી બહાર કાઢો. So on the judgment is 4/7. It appears on 17/7/2013. 13 days later, a representation is made that keep sugar factories out of 74C.
Yes, Mr. Joshi.
So, Manoj, the minute the matter is pending before the High Court, and soon after the decision, a representation is made that excludes sugar factories from 74C. Complete obstinate attitude of not going by elections under 11C. And Mr. Jani Maus, I'm obliged, he has taken a lordships to great details to the documents that self-serving documentation is made. And he has taken a lordships to the entire history from that date till the passing of the order. All documentation by Director of Sugar not stating the correct facts. I only adopt what he has said. So now this is the resistance. Now, Manoj, this goes to the Honorable Supreme Court. And please see one observation of the Supreme Court in the judgment which I have already read. That is at page 89 of Mr. Thakur's compilation. 2015-13 SCC.
Which paragraph?
29 now in this context that there is an obstinate attitude and the Supreme Court also has some reservations. Paragraph 29 on page internal 416, printed 416.
Yes.
For the reason stated supra, we do not find any reason to interfere with the impugned judgment. Now this included the full bench judgment which I read. 4713 order was before the Supreme Court. It is needless to make an observation that the state government and its officers could not could not give effect to the provisions of the Cooperative Societies Act and rules for some time, on account of which some of the societies have challenged the impugned provisions and the rules before the High Court. Even after litigation was concluded by the division bench, at one stage, the state and its officers have not implemented the impugned provision and the rules without any valid reasons. The members of the specified societies have a right to elect their true representatives to represent them as the managing committee of the board and other allied societies after delimitations, and therefore we direct them to see that the impugned provisions and rules must be implemented forthwith without delay and submit compliance report. Please see reservation that the state, some officers of the state are also not implementing these provisions. This is the background, and the Supreme Court says give a compliance report, and then Manoj, the entire exercise being undertaken, etc. at this stage. So Manoj, as I said, this is the third parameter of manifest arbitrariness which the court may take into account. Then lastly, Manoj, Mr. Soparkar said, but your grievance of constituency-wise elections from his two sentences is misconceived because societies have constituency-wise election bylaws. First of all, it is much after cracking of the whip by all courts that they finally said that all right, the amendments be done. Two, the validity of a legislation is not dependent on a circumstance whether a society has or has not amended its bylaw. The validity of a legislation, whether constituency-wise representation in one society is assured or not, or all societies assured or not, is no indicator for the validity of the legislation. It is just a circumstance which, if left to the society, would undergo a change next time. That is not permanence. A bylaw existing today will not validate a law which says there is no mandate to have constituency-wise election. Therefore, it is no answer to say, no, but we are taking care of it in our bylaws. That's not the point. The point is of a statutory mandate where the elected body is bound to comply day in and day out. The fact whether one society has or does not, or all have or not, for the present, it was never voluntary. It was made as a law and implemented much later. If that law goes, the Lordship can take it from us the bylaw will go. There was no bylaw. The law was imposed. It required enforcement by the Supreme Court. Now they say, no, but we have amended. So that, Manoj, is a completely irrelevant circumstance. And most importantly, Manoj, despite this, when the elections are going ahead, despite your lordships considering the matter, since your lordships had not expressly granted any stay and said subject to etc., no results to be declared, the ballot papers indicate, as far as the society which we have annexed, 16 votes for all. So this argument of the bylaws taking care of constituency-wise representation is misconceived. That ballot paper, is it in Gujarati? That I have, Mr. Desai.
Yes, it is in Gujarati along with that ABCD compilation. The last.
Yes.
It is. त्रिवेदी साहब आपने पर मोकल्યું છે.
1 2 3 4 5 6 7 8 9 10 11 12 13 14
जब बूथ वाइज कर दिया एक ही पे दिया
depend by Mare.
Last page ABCD.
Ballot paper is sent to you by WhatsApp also.
Should I open up my email or WhatsApp?
WhatsApp.
So Manoj, so my friend may be right. I will wait till he elaborates it. But the bylaws may now provide constituency-wise. The problem is, the interpretation is that all members can vote for all constituencies. Therefore, we come back to the flaw, as a result of which
there are 10,000 members, so they would all be voting for 15 seats.
That's right. And therefore,
15 votes in favor of 15%.
That's right. Which the Supreme Court said amounts to giving 15 votes instead of 1, will skew the representation, because a taluka which has more members.
There could be candidates
हाँ
who would
from
be
one
elected
constituency.
only from one
Constituency तो रहने की ना आप सर.
अब नहीं रहेगी.
तो constituency है नहीं.
नहीं.
15 लोग खड़े हो गए, 15 लोग
So all will vote for it.
So, but as I said, that is a factor which may not be relevant for the purpose of testing the validity of the legislation. Even if bylaws in compliance with 3A8 have got constituencies, it makes no difference. The point is, why others also have the same thing? Why did you exclude cooperative societies? All specified societies bylaws are bound to comply with the mandate of 3A of constituencies. Just because societies also have it is no reason to exclude it. It is similarly situated on this point as with all other societies. And that is not the state's point at all. State has not supported the legislation on this ground. Therefore, according to me, it's irrelevant. I will elaborate if required after Mr. Soparkar says. So this, Manoj, I support what Mr. Thakur and Mr. Jani has said. Manoj. The provision is clearly arbitrary, discriminatory, suffers from manifest arbitrariness, deserves to be struck. Deeply obliged, Manoj. That is all I had to say.
Yes, Mr. Trivedi.
Lordship. I request my lords to take up Mr. Thakur's petition, 5301.
Like 10 minutes में join करें कहाँ से?
Mr. Trivedi, can we have a 5-7 minute break and we join after 5-7 minutes?
Certainly, my lord. As my lord's praises.
In the meantime, you can comprehend all the arguments and
Lordship.
Which is my pardon, may I take leave of the for the time being? I may take leave with your lordship's permission, Manoj.
As you wish.
Lordship.
These are lordships.
પેલા માસ સારું થઈ ગયું.
He wants 5301.
Mr. Mehta. Yes.
Please, Your Lordship. Lord, I just indicate, my Lord, how do I propose to proceed in the matter, my Lord.
Very well.
Lord, I intend to read, my Lord, paragraphs, my Lord, 3 to 5 of my sub-rejoinder affidavit.
Yes.
Lord, Lordship may find me texting, but I would like to read, my Lord, line by line. And that is going to be, my Lord, my common, my Lord, affidavit in all the petitions. My Lord. Then I propose to, my Lord, take my Lords to, my Lord, the arguments which have been advanced by all the my learned friends, my Lord. My judgments and distinction, my Lord, of their judgments, my Lord. So before I do that, my Lord, let me make a prefatory remark to the whole issue, my Lord. My Lords are well aware, my Lord, a legislation can be challenged, the validity thereof, now, my Lord, on 3 grounds. Ground number 1, lack of competence, my Lord. So my friends have been kind enough to admit that I do have a competence, so no issue arises of debate on that particular aspect. Second ground, my Lord, is violation of any constitutional provisions. Here the stress is there is a violation of Article 14. I need to explain that there is no violation of Article 14. And the argument is there is an unreasonable classification. Whatever classification we have made is artificial, is not genuine. There is no, my Lord, purpose sought to be achieved, so on and so forth. And what I propose to do, my Lord, is, my Lords are well aware, for testing as to whether Article 14 is complied with or not, as my learned friends, my Lord, have stated in detail, 2 things are required to be satisfied, my Lord. The classification must be based on intelligible differentia, which distinguishes entities which have been grouped together from those entities which have been left out. So I need to show today which are these 2 different groups, how do they differ?
Correct.
And secondly, my Lord, that differentia must have a rational nexus with these objects sought to be achieved. I quite say, my Lord, object may not be liked by the other side. In reality, are those objects hold the field or not? Nexus is required to be, my Lord, appreciated from that point of view. Today, what do we say, my Lord? Lord, when Sugar Cooperative Society was put in a specified list, I would say this, my Lord, it was an odd man out. Odd man out in this wise. Barring sugar cooperative societies, all the societies which were grouped together under the list of specified cooperative societies were federal societies. So one kind, my Lord, belittle this distinction, my Lord.
Now, the federal society, the only different character would be that they would have cooperative societies as members of the
Lordship places. So this was, my Lord, the first differential, my Lord. Today, my Lord, I am taking that odd man out and putting it in his family, where there are 81,000 cooperative societies holding elections, my Lord, not in accordance with Rule 3A. You know, these 2 judgments were cited as if I am in a contempt jurisdiction, my Lord. What is wrong if the society is taken out and given, my Lord, free role to, my Lord, play? Anyway, my Lord, the first differential, my Lord, in my view is that this is, one is, my Lord, a group consisting exclusively of federal societies. And the group which is exclusively of primary cooperative societies. The entity, namely Sugar Cooperative Society, which was an odd man out in that group, has been now, my Lord, relegated to its family. Differential number 2, my Lord. All these specified cooperative societies have, my Lord, a 3-tier or 2-tier cooperative credit structure. Let us take an example of, my Lord, a district cooperative bank. There is an apex body at the state level. At the district level, my Lord, there are district central cooperative banks. Then there are credit cooperative, my Lord, societies at the grassroots level. This 3-tier or 2-tier credit structure plays a very important role in the economy, my Lord, so far as cooperative sector is concerned. Sugar Cooperative Society doesn't have any tier. They are direct members. There is nothing like indirect membership, And the third differential, and this differential is very important, each of the bylaws of each of the sugar cooperative societies functioning today, namely 13, the area of operation has nothing to do with a particular village or a district or a taluka. Area of operation is radius of 40 kilometers from my factory, which is normally located in the vicinity of sugarcane fields. I'm not concerned with a village or a taluka or a district. In this 40 kilometers radius, if more than villages come, it's a matter of just factual coincidence. But they are not concerned with a particular village or a particular taluka or a particular district. Whereas specified cooperative societies, from the point of view of that area of operation, they are either confined to the district or confined to the taluka or confined to the village. Such kind of division of area of operation is not there in a sugar cooperative society. Now, one can't lose sight of the fact, why was sugar cooperative society included below? Amreli district judgment below was dealing with generally as to whether there is anything wrong in bringing section 74C, whether there was something wrong in carving out a list of specified societies, where sugar cooperative society was one of the constituents. All the while, the discussion which has been followed in the judgment is with reference to specified cooperative society as a whole, not with reference to individual sugar cooperative society. And para 66, which has been read and reread, the Lordship may find the expressions transparency in the election, malpractices in the election. Such a language was not there in the statement of object and reason. That language was taken from my affidavit, which was filed on behalf of the state government at that particular point of time. Fair enough, nothing wrong in it. But that affidavit also said something more than that. And that was, my lord, sugar cooperative society was included, keeping in mind at that time a subscription made by the state government to the capital of the sugar societies, which was starting from 1978. My learned Mr. Joshi tried to say that pittance was given. But 20 lakhs or 1 crore at that time was a big figure, my lord, in the year 1978. You may not find that figure big today. But that was the reason for which sugar cooperative society was put in the list of the specified cooperative society. I quite see, my lord. What was observed by the learned division bench was that because of this reason, if the state government is giving, what is wrong in allowing the specified societies to be subjected to the rule of the collector where the elections can be held under his aegis? Nothing wrong. Now, my lord, comes, my lord, whether there is any rational nexus of this differentia with the subject or object sought to be achieved by my amendment. My lord, mainly my SOR says two objects. As my lords have taken note of, my lord, repeatedly, my lord. The expenditure. My lord, the figures of profits were not given, my lord, to be little. Figures of profit were given that please don't say this, the expenses is not a burden. Societies themselves have been saying consistently right from 2013. Please exclude us, please exclude us. So, my lord, that is, my lord, a nexus that the objects sought to be achieved, because in all other primary cooperative societies, my lords, my lord, I'll give the list at the relevant point of time, my lord. Today, my lord, 81,156 are the primary cooperative societies operating in the state. Forget about, my lord, those housing societies. My learned friend Mr. Jani said there are 17,000 housing societies. Fair enough, forget that. There are 225 urban cooperative banks. And my lords Padiwala may appreciate, my lord, Waracha Cooperative Bank and Surat Cooperative Bank, urban banks. The combined turnover of these two banks is more than 10,000 crores, as against the combined turnover of the sugar cooperatives not exceeding 4,000 even. It is hardly 3,800. If one takes below all 225 urban cooperative banks, which are primary cooperative societies in terms of turnover, in terms of below earning, in terms of below members, they are far ahead of below the sugar cooperative societies. We can't make this kind of a comparison below. There are about 9,693 large area multi-purpose cooperative societies below. There are below more than 6,000 below credit cooperative societies, where elections of all these societies is being conducted not in tune with Rule 3A8. What is so wrong? Where is the embargo that election cannot be held? Mr. Joshi read one of the judgments of the Supreme Court, Rule 402. That rule was identical, like Rule 3A8, what we have. If I put somebody in a group of specified cooperative society for which the specified 1982 rules are framed, the election is to be governed by that. If you don't belong to that particular list, nobody is committing sin. There is also a valid way of conducting election since ages below. In many of our non-statutory organizations like clubs and other associations, elections are being held in the same fashion. There is nothing wrong. So in my humble submission, below today, second ground, namely classification is unreasonable, I will satisfy my Lord that reasons may not be liked by that. But there is a genuine reason for which below classification is based, with different to a group which is very much distinguishable from the group of specified cooperative societies. And the third ground, manifest arbitrariness. Below, in my humble submission, I pose a question below. It's very easy to term anything manifestly arbitrary. Two judgments have been cited by all. Saira Banu. I pose a question to myself, Lord. Why was Section 2 of Muslim Shariat Personal Act was set aside as manifestly arbitrary? The reason is this. The whole act is aiming at preservation of a marriage, saving the marital ties. My Lord Justice Nariman observes, unfortunately, Section 2 runs diametrically opposite to the whole law. Section 2 is whimsical. Section 2 is capricious. Section 2 is irrational. Why? Because it says you utter three words, talaq, 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 marriage will be broken. No attempt to reconcile the marriage. And that is how Section 2 was held to be manifestly arbitrary. Do we have that kind of a manifestly arbitrary law? My answer is no. The second case, Navtej Singh Johar belong. What were the facts? My Lord Justice Padiwala, I appreciate belong. Section 377 was struck down. Why? I pose a question to myself. Because what was punishable in case of consenting adults of same sex was not punishable under Section 375 in case of consenting adults of different sex. Supreme Court said this is obnoxious. This is capricious. That's how 377 was struck down as manifestly arbitrariness. Where do I find this kind of obnoxiousness? Merely because two reasons added by two more reasons in my affidavit are not liked by them? I quite say, Milord. Argument is expenses on a higher side may be an element applicable to other societies also. Fair enough. Tomorrow we may try to separate out one more society. What is wrong? Question is, do we have a power to do that or not? Question is, do we have done on some logical ground or not? My friend Mr. Waghela can say, because they have reached the last point of election, what are the expenses incurred by that? Is it amount as compared to expenses incurred 5 years back? Answer is no, my lord. Today, my lord, they have incurred expenses hardly of 4.5 lakhs. In 2015, to the collector's office, they have incurred the expenses of nearly 8 lakhs. So what is so wrong? I quite see. Earlier also society was incurring expenses. Today is also expenses they are incurring. But it was the consistent representation from their end right from 2013, 14, 15, 17. And ultimately it is a legislature which fills the fill of the people at large. If the legislature has taken this task, what is wrong in it? And I must say, beloved, with both folded hands, beloved, my learned friend Mr. Jani referred to several consequences. It is not a matter of consideration so far as validity of the legislation is concerned. Somebody tomorrow say that there is a likelihood of abuse. Fair enough. There may be a likelihood, beloved. On that ground, a legislation cannot be struck down per se unconstitutional, beloved. Whether there is a mala fide or not, whether there is ulterior motive or not, whether there are consequences likely to follow which are of disastrous nature, they are not below the matter of consideration. Only 3 points: my competence, whether violation of constitutional provision, and whether there is manifestly arbitrariness or not. If I pass through this triple test, Lord, no grounds will be available for striking me down. Now, with this, Lordship, I will just pick up my affidavit, Lord. Affidavit in Surrey Joinder in 5301.
Just 1 minute, Mr. Trivedi.
Lordship.
Yes, Mr. Trivedi.
May I request my lords, Lord,
No, Mr. Trivedi, we have something to say.
Lordship.
You have given us a bird's eye view of the entire submissions that you are likely to advance, right?
Lordship.
And because today's bench is only up to lunch time, 1:45.
I quite similar.
We hardly have 10 minutes left. So we would like you to start your arguments on Monday at 11.
Lordship, please. I'll be here.
And in continuation, we'll hear the other counsels for the respondents and other petitioners, and then we will take up the petitioners' counsel in rejoinder.
Lordship. Perfect, Lord.
Right? So Monday 11 a.m.
Perfect, Lord. Lordship, please. I'm good.
If they're not keeping tomorrow or day after.
No, too.
They're not keeping tomorrow or day
After is a holiday.
Bench is not available.
Bench is not available, Saurabh bhai.
Okay, no issue. I'm
No,
so sorry.
We'll be
Okay,
here
on Monday then, sir.
on Monday.
And day after is a holiday.
Oh, I'm sorry, sir. I lost. Presently, every day looks like a holiday, so that's a problem.
No, don't say that.
It's a
Sir.
lordship.
You for us, it's a working day.
Holiday, but we all are not very tuned to the dates.
No. You should say we are
Because-
working also on holidays.
All right.
No, because okay.
We have heard Shri Mihir, in continuation of yesterday, we have heard Shri Mihir Joshi, learned senior advocate, assisted by Shri Deepen Desai, learned counsel for the petitioner in SCA 4449 of 2020. Full stop. The arguments of Shri Kamal Trivedi, learned advocate general, for the state respondents are continuing. Put up on Monday, 2nd November 2020, to to be taken up at 11 a.m. For further arguments. Okay.
My lords, we have supplied the additional affidavit also.
The additional affidavit आ गया ना? आ गया. The additional affidavit filed by Mr. Jigar Gadvi.
Please, my lords.
Learned Counsel appearing
Yes.
for the Sugar Federation is taken on record.
Lord, I have filed 2 petitions challenging the order passed by collector, wherein the permission is granted to the society, sugar societies, to conduct the election. Those matters, my lord, will come, my lord, either tomorrow or on Monday, my lord.
So you can give the number.
On Monday, my lord, if both the matters may be listed on Monday.
You have the filing number?
Filing number, lordship, please.
You have the filing numbers?
I have the filing number.
So you.
I will give it to Mr. Gadvi, my lord, so that.
What is the relief claimed in those petitions?
Yes, my lord, challenging the order of collector wherein the permissions are granted. My lord, our contention is there are 6 cooperative societies who have issued notification for election. Till pendency of these petitions, my lord, challenging the virus, elections may not be conducted by the societies.
So we are not granting any stay.
My lord, that they in one of the matters, my lord, on 14th October, it is an order passed by this honorable court, my lord, wherein in one of the societies, Narmada Sugar, the directions is given not to declare the results. Since the elections were under process, the order is passed against Narmada Sugar Society not to declare the results. In other societies,
in your case, the election notification schedule has not been declared so far.
Yes,
in some societies, in 6 societies, the notification is issued. Election process has not commenced.
No, same order can be passed, my lord.
My lord, if the elections are held, my lord,
Sir, Archit Jani, in your petition also, election, the virus of the section 74 is challenged?
No, my lord, virus is not challenged. I am challenging the order of collectors wherein the permission is granted.
For the single judge?
My lord, since single judge has referred the matters before this honorable court, my lord, since in other cases, my lords have, my lord, appreciated, my lord, those facts. In Narmada Sugar, my lord, the order is passed on 14th October.
Mr. Archit Jani, advocate, state that he has filed 2 petitions, which are still in the process of clearance of objections in the registry. However, filing number of these petitions have been allotted. He submits that these 2 petitions may also be taken up on Monday along with this group of petitions, as similar questions would be involved. Okay. The details of the 2 petitions are as follows. ये number बताएंगे, note कर लीजिएगा अपने. ठीक. Office to place these 2 matters also along with this group of petitions on Monday. ठीक है.
Thank you, Lordships.
Maybe leave it alone.
Yes, thank you.
May we leave, my lord?